What you know, Alibiers? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Monday, January 13th. I was supposed to be sitting in the Rose Petal murder trial for the next 2 or 3 weeks, but they weren't able to find enough jurors that could commit to 2 to 3 weeks for the trial. So they're going to reset. Maybe in about 45 days, we get another shot at it. Packed up, came home, and got some new Kouri Richins filings. So I thought we would go over some of those. There are several. It's going to take a few episodes to go through each one, but we're going to start with 3 of those filings today. All 3 of these were dated January 8th. And the first we're going to go through is the motion to suppress electronic data. Kouri wants to suppress all evidence obtained from the search of Kouri's cell phone and Apple user IDs pursuant to search warrants. Kouri seeks to suppress the contents of the search of her cell phone. Kouri has standing as the cell phones and Apple IDs were hers. The issue raised by this motion is whether the searches were based on a warrant that lacked particularity and was overboard. First section is the relevant background. Kouri was arrested on May 8th, 2023, and her phone was taken from her during her arrest. 2 hours later, a warrant was issued. The warrant authorized the search of electronic documents, email, instant messaging and texts, personal communications, internet history, personal and business schedules, photos, images and videos, contact lists, phone numbers, call history, GPS location history, social media activity and messages, all other digital activity stored on this device. On May 8th, 2023, during the execution of the search warrant on Kouri's residence, a phone was found in a drawer and a warrant was requested and issued for the same 11 items above. On June 27th, 2023, a warrant was issued for a white iPhone 13 belonging to Kouri Richins, which was seized. The same 11 items were requested. Lastly, prior to Kouri's arrest, a warrant for her Apple information was issued. That warrant requested the following: device registration, customer service records, Apple Media Services, Apple Store transactions, Apple.com orders, gift cards, Apple Cash, Apple Pay, iCloud, Find My, AirTag, and Find My Network accessory programs, extracting data from passcode locked iOS devices, IP address request, other available device information, requests for Apple Store CCTV data, Game Center, iOS device activation, connection logs, My Apple ID, and I Forgot logs, FaceTime, iMessage, Apple TV app, sign in with Apple, and any and all location data. Detectives had the ability to limit their scope, but chose not to. Instead, they left it broad, not even limited to the date of the alleged crimes. The next section, grounds for suppression. The warrants were improperly issued because the supporting affidavits lacked particularity and were overly broad. As a result, the searches violated Kouri's rights under the 4th Amendment of the U.S. Constitution, which, just a reminder, it protects citizens from unreasonable searches and seizures by the government, and also Article 1, Section 14 of the Utah Constitution. That says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, particularly describing the place to be searched and the person or thing to be seized. The next section, lack of particularity. The 4th Amendment requires that warrants particularly describe the place to be searched and the person or things to be seized. The affidavit in support of this warrant in this case failed to meet the standard with respect to Kouri's phones and Apple IDs. The warrants authorized a search of the entire contents of the phone without the entire contents of the phone and IDs without specifying the particular information sought, limiting the scope of the search to evidence related to the alleged crimes of murder and attempted murder, or establishing a limiting search procedure. This broad authorization allowed law enforcement to conduct a fishing expedition through Kouri's private data, far exceeding the permissible scope of a warrant. They go on to cite some case law, State versus Fuller and State versus Hoffman, to support their argument. The next section is overbreadth, which is another word for overbroad. The warrants were overly broad in that they allowed the seizure of all data on Kouri's phones and Apple IDs, regardless of their relevance to the alleged crime of murder. The affidavit failed to establish probable cause to believe that all data on the phone, including personal communications, photos, and other private information, would contain evidence of criminal activity. The warrant should have been limited to specific types of information or files that were reasonably likely to contain evidence related to the alleged murder and attempted murder. They cite the same two cases we just mentioned. And their argument, the search of Kouri's cell phones were in violation of her constitutional rights. The affidavit supporting the warrant lacked the necessary particularity to justify such broad intrusion into her personal life. The warrant's overbreadth allowed law enforcement to seize a vast amount of data unrelated to the alleged murder, violating Kouri's reasonable expectation of privacy. The warrants in this case failed to adequately protect those interests by providing specific limitations on the scope of the search. The defense requests evidence be taken on this issue at the previously scheduled evidentiary hearing, which, by the way, that hearing, I believe, is set for January 23rd. I will double check to make sure that's correct, and I'll probably run that live on my channel when it does happen. They go on to say, additionally, defense anticipates that further briefing will be required following the evidentiary hearing in this matter and requests leave of the court to supplement this motion with a memorandum of facts and law upon conclusion of the hearing. The next filing we're going to talk about is a motion to suppress statements made by Kouri and evidence seized from her person and her home. It says that she is seeking to suppress physical evidence, specifically a telephone, and all evidence obtained from the phone, which was seized from her person on April 13th, 2022. Also, it seeks to suppress all oral statements made by her while she was detained on April 13th, 2022, during a search of her home. Oral statements she made during an interview with Sergeant O'Driscoll at her home on April 14th, 2023. Handwritten statements seized from her home on May 8th, 2023, on the grounds it was seized without the proper authority of a warrant and is protected by physician-patient privilege. Ms. Richins has standing as she was the individual who made the statements. The first issue raised by this motion is whether the physical evidence seized from Ms. Richins' person on April 13th, 2022, specifically a mobile phone, was seized and or assessed without the lawful authority of a warrant, and whether all evidence seized from that phone is the fruit of a poisonous tree. The second issue raised in the motion is whether the statements described in paragraph 2 above were custodial statements made by Ms. Richins without the benefit of being advised of her Miranda rights. The third issue raised by this motion is whether the statements described in paragraph 3 above was obtained in violation of Ms. Richins' constitutional rights, considering her right to have an attorney present was previously invoked. The fourth issue raised by this motion is whether the statement described in paragraph 3 above was seized without the proper authority of a warrant, and, if so, whether it's protected by the mental health therapist patient privilege. Kouri respectfully requests an evidentiary hearing and subsequent leave to file a memorandum of authorities in support of this motion. They go through relevant background. On April 13th, 2022, search warrants were executed on Kouri Richins' home and items were seized from her house. During the search, Ms. Richins was pulled over in her personal vehicle a short distance away from her home. Law enforcement officers seized her personal phone from her vehicle without the authority of a warrant. For over 5 hours, was not free to leave the scene. At the time of the search, law enforcement was aware Ms. Richins was represented by counsel and even had set up a time for counsel to appear with Ms. Richins the next day at 8:30 a.m. During the time she was detained, Ms. Richins was questioned by law enforcement without the benefit of a Miranda warning. Law enforcement used the information they received from Ms. Richins' custodial statements on April 13th to obtain physical evidence to use against her. On April 13th and 14th, Ms. Richins' attorney sent an email to the Summit County Sheriff and to the county attorney's office advising that their firm represented Ms. Richins and objecting to their attempts to question Ms. Richins outside counsel's presence. Copies of these letters were sent directly to the main case investigator on April 14th, 2022. On April 18th, 2023, Detective O'Driscoll appeared at Ms. Richins' home with another police officer and hidden recording devices and questioned her for over an hour, despite the previous invocation by counsel of Ms. Richins' Fifth and Sixth Amendment rights. At no time during the interview was Ms. Richins advised of her Miranda rights, and her attorney was given no advance notice this interview was going to take place. Ms. Richins was arrested on May 8, 2023. On the same day, law enforcement executed a second search warrant on the Richins' home. This warrant did not authorize the search or seizure of documents. While the officers were searching the home, they came across a closed notebook. The officers opened the notebook, read its contents, and then sought an amended warrant with authority to seize the notebook. The officers' acts of opening and reading the notebook without authority of a warrant to do so violated Ms. Richins' Fourth Amendment right to be free from unreasonable searches and seizure, and tainted the second warrant since it was based on this unconstitutional seizure. This document was prepared at the request of and for review by Ms. Richins' therapist and is privileged. The next section, grounds for suppression. Number 1, the seizure of Ms. Richins' phone from her person on April 13th, 2022. The Fourth Amendment to the United States Constitution provides citizens with a right to privacy and prohibits unreasonable searches and seizures of their persons or property. The seizure of Ms. Richins' phone without the proper authority of a warrant violated her Fourth and Fifth Amendment rights. Because Ms. Richins was not arrested on that day, the incident to arrest exception to the warrant requirement does not apply, nor do any other exceptions. Number 2, oral statements made by Ms. Richins while she was detained on April 13th, 2022. The Miranda safeguards apply when an individual is taken into custody or otherwise deprived of her freedom by the authorities in any significant way. They cite State versus Fullerton. At the time of Ms. Richins' statements on April 13th, 2022, she was not free to leave and she was not read her Miranda rights. Therefore, any statements obtained from her during this time violated her Fifth and Sixth Amendment rights and must be suppressed. Any evidence obtained as a result of her statements must be suppressed as fruit of the poisonous tree. The Fifth Amendment creates a privilege that protects a defendant against being incriminated by his own compelled testimonial communications, and they cite State versus Valdez. An individual has a Fifth Amendment right to refuse to provide a cell phone swipe code to investigating officers. Number 3, the interview with Detective O'Driscoll. Detective O'Driscoll conducted the interview of Kouri Richins while on notice that she was represented by counsel and that her prior counsel had invoked her Fifth and Sixth Amendment rights. Even knowing this, he proceeded with the interview with the intent to get Ms. Richins to incriminate herself, knowing she was going to be arrested shortly thereafter. At no time did he offer Ms. Richins a Miranda warning, Such an interview was a clear violation of Ms. Richins' Fifth and Sixth Amendment rights. Number 4, the handwritten statement in the orange notebook seized on May 8, 2023. The warrant authorizing the search of Ms. Richins' home on May 8th did not authorize law enforcement to seize and review documentary evidence. Nevertheless, officers opened up a closed notebook and read the contents. Realizing they did not have the authority to do so, they obtained a second warrant attempting to authorize the illegal seizure they had already conducted. The seizure of the notebook violated Ms. Richins' Fourth Amendment right to be free from unlawful searches and seizures of her private writings within the privacy of her own home. Furthermore, Rule 506 of the Utah Rules of Evidence provides that documents prepared under the direction of a mental health therapist for purposes of mental health treatment are privileged documents and cannot be introduced at trial. The defense requests evidence be taken on these issues at the previously scheduled evidentiary hearing. Additionally, defense anticipates that further briefing will be required following the evidentiary hearing in this matter and requests leave of the court to supplement this motion with a memorandum of facts and law upon the conclusion of the hearing. And the last one we're going to go through today is the motion to suppress the walk the dog letter. It says Ms. Richins is asking to suppress the 6-page walk the dog letter found in her cell and seized on or about September 14th, 2023. Ms. Richins has standing as the letter was written by her and was located with her property in her cell. The issue raised by the motion is whether the letter constitutes attorney-client work product and or attorney-client communications and is therefore privileged. The next section, factual background. On or about September 13th, 2023, Ms. Richins was transported to the hospital after suffering a medical incident in her cell. While Ms. Richins was at the hospital, jail staff entered and searched her cell, possibly looking for a letter Ms. Richins had shown her mother during a video call. In the footnotes, by the way, it says this letter was ultimately determined to be a letter written to Ms. Richins by another inmate and was not the letter that is the subject of this motion. Nothing was initially taken from the cell. However, over the course of 24 hours, the cell was searched 2 additional times. During the final search on September 14th, 2023, jail staff seized the 6-page letter now known as the Walking the Dog letter. Ms. Richins maintains the letter was located in a manila envelope marked Sky Lazaro Attorney Privilege. In the footnotes, it says the manila envelope contained a fictional manuscript, which this court has previously ruled attorney-client communication and work product and therefore privileged. Whereas jail staff had stated the letter was located in a book titled 10 Actual Official LSAT Prep Tests. This letter is not addressed to anyone, and there's no evidence the letter was shown or mailed to any person. The letter, at least in part, discussed conversations and legal strategies that took place with Ms. Richins' former counsel, Ms. Lazaro. Next section is the analysis. They talk about how communications between a client and their attorney are protected by privilege. They cite case law to support their argument. The letter at issue meets the criteria to fall under work product privilege. It is a tangible document that discusses legal strategies in preparation for trial, prepared by or for another party. Further, according to the defendant, the letter was in an envelope that was marked as attorney-client privilege. And even if the letter was in a book, it clearly discusses legal strategy and still meets the criteria. It's neither addressed to anyone nor signed by Ms. Richins, and there's no evidence she intended to disclose it, thereby waiving privilege. Lastly, the letter has been identified as part of the fictional manuscript this court has previously ruled is privileged, and therefore, as part of the manuscript, is clearly privileged. Ms. Richins anticipates that further briefing will be required following the evidentiary hearing in this matter and requests leave of the court to supplement this motion with a memorandum of facts and law upon the conclusion of the hearing. So those are the first 3 filings we're going to go through today. There are plenty more where that came from, y'all. Every day I'm going to tick 2 or 3 off of the list, and that way we are current and ready for that hearing when it pops up here shortly. All right, that's it for today. Hope you guys have a great rest of your afternoon. We will see you soon.